possible code amendment for Idaho Department of Corrections for the Reentry Center. And this calls for potential action item, which means, folks, that we could hold a possible vote today on the proposed code amendment. Director Callahan?
Not quite.
Yeah.
Let me offer a few.
You could direct staff to move forward with the process.
That's really the purpose of this discussion. Let me back up and give you a little context.
Go ahead, back up.
We have regulations in place that could shoehorn in a conditional use permit review for this sort of group. I would rather it be crystal clear. If you are getting the sense from the state or anywhere else that we're going to get one of these reentry centers, my advice is that you instruct the staff today to work with the Planning Commission, which we have to, come up with a new set of standards for one of these facilities, and then it would be in front of you through a duly noticed public hearing. It would also go to the Planning Commission first.
So that's what you mean by an action item,
Yes, sir. You'd be, what Pat said, you'd be authorizing or directing your choice, staff, to move forward with a code amendment.
Understood.
But I'd like to get a sense from you what kind of code amendment you'd like. What I sent, what's on the screen and what I've sent to you by email is a approach I happen to know of from a place I used to work. And the usefulness of it is it gets to what the Planning Commission is concerned about, which is we could make it so expressly detailed in dimensions of how far away it has to be from residential and commercial, and it can only be in these certain zoning districts, and so on and so forth, that you make it a relatively rare thing that can happen in this county, and therefore can be approved by right, possibly. I say it that way because our Plan Commission is hoping that we go through the entire code, our current Planning Commission, and eliminate some of the many conditional use permit procedures we now have. They'd rather see more things by right with standards built into it. So one approach would be a by right use. That's kind of what you see on the screen here. Although in this particular case, the community I borrowed it from still did it by CUP. They have some express standards that you saw, and I left them in there. So it can go CUP, it can go by right, it could be a combination of the two, by right in some zoning districts, by CUP in others. That's the level of detail we would presumably work through with the Planning Commission for public hearing and then you. But what I really need to hear from you today is whether you think this kind of need is imminent and necessary and we should just get started on it.
Thoughts? Leslie? Bill?
I think it's a good idea to bring it forward to the Planning Commission and see what their thoughts are on it. I'm wondering, and this is more of a question for Pat, and if you can't answer it now, that's fine. Can we put in our code something that says it has to be privately run and it cannot be government run?
You could. I think that would be maybe subject to challenge by the state, but I mean, we have other uses that are expressly public or private, so.
So
that is a possibility.
when we had the Federal Reentry Center here at Coeur d'Alene, it was privately run, and I'm not aware of problems that, and so my concern is the public versus privately run thing, because I think privately run has a little bit more motivation to say that they're going to do things.
It could be, bear in mind, they'd still be a government contractor,
Sure.
and the governmental entity that sponsors it would still be responsible for any
Sure.
wrongdoing.
Sure. Okay. Yeah, and that's fine with me.
Bill, thoughts?
Well, when David talks about by right or by conditional use permit,
Yes, sir.
I like the conditional use permit. There are a lot of things that we don't want that someone could, as you say, shoehorn their way in by
Right.
doing all the things that by right and then say, I demand it. Now,
If it's by right, they meet the requirements, we can't say no.
that's what I mean. I like to say no when I need to.
Right.
So
I get that.
I don't like, I wanna do it by conditional use permit, or at least have that vote, and I don't much care whether it's public or private. There are problems with both, and the director of the Department of Corrections, told me, we don't go where we're not wanted. That's what he told
Did
me.
he say how they get that sentiment?
He just said, we don't go where we're not wanted. And as someone who talks to a lot of people,
That would be the usefulness of a CUP, is we would hear that loud and clear.
loud and clear, that's right. And I've heard about 90 to 95%, we don't want it.
I have to.
Okay, I understand. I think that's important to keep in mind, that, that message, I didn't say, you shouldn't go where you're not wanted. He said, we don't go where we're not wanted.
Well, I actually find that encouraging.
Well,
Yeah, that was actually a quote in the newspaper
Newspaper?
too. Yeah.
Okay.
right, did he say that?
Yep.
Okay, well, I take him at his word, so that's not a problem.
Well, you know.
Okay.
I just think going down this road is starting to monkey around with by right, like, is the camel's nose in the tent. And I just assume keep the camel's nose out of the tent, whether it's public or private. My problem is, I think commissioner's first duty is to protect the public. And I think having one of those in this county puts the public at risk. So, if that tells you where I'm coming
Are you
from.
comfortable with the notion that you would have one somewhere?
In
Is
Kootenai
it
County?
conceivable to you that it could go somewhere in the county?
No,
So in that case, there's no reason to do this at all.
that's right.
Okay.
So right now, there is no place in the county that is permitted by
Well,
CUP or by right?
Actually, the correctional, Pat will have to help me, there's
By
a section
CUP?
in the correctional facility, we just wrote in the last,
Yeah.
you know what I'm
Right.
talking about?
Yeah, I do. My computer's not
Oh, okay.
working right now. But
I
I know,
think
I
it-
know in the code it is addressed.
When we were looking at doing the sheriff's, the jail expansion, we amended the code to make it clear
Correct.
that we have those kinds of facilities in the county. I think it's conceivable this use could fall under that jail facility.
It's, well,
That's where I need to go
a
back and do the
halfway house
research.
isn't really a correctional facility.
But the language we have is broad.
Yeah, I'd have to.
We'll need to go back and
I have to
look.
go back and look at it, but there isn't anything expressly addressing this.
Right now today. And
Yeah.
I think the usefulness, especially even if you don't want it, the usefulness of having something like this in here, and we limit it to some very refined areas and by CUP, is it's unambiguous, we're capturing this use. And if it does land here, it's going through this process.
Right, but with the CUP attached too, even if you have this
Mhm.
strict regulations plus the CUP, then,
Then you can still deny it,
yeah.
or any future board can too.
So the federal reentry center that was here in Coeur d'Alene in years past, if it was in the city of Coeur d'Alene, then this doesn't,
Right, the city has their own regs.
okay?
Right.
Yeah, we don't have jurisdiction there.
Right.
Yeah, I mean, it's an interesting discussion, and I remember having this discussion with a former county commissioner before I took office. And I was trying to make the case that we really ought to minimize the CUP process and allow more by right, as long as it's appropriately defined and protects, the health of the county, if you will, and its residents. But there are gonna be those situations where it's just inappropriate, so I think I'd almost be in favor of preserving the CUP process insofar as this type of establishment is concerned.
Okay.
Now, my understanding, and I've heard this from at least one of our legislators, is that when this was passed in Boise and funded, that it was targeted for Kootenai County, and I stand to be corrected if I'm wrong, but that is my understanding. That it is targeted, I see the nods, that it is targeted for this county.
Okay.
I'm gonna leave it at that, I can't opine any further because I don't know
Well,
whether
that
that
would be the
means.
reason to do something.
There you go.
Okay.
That's my concern. So that would then almost, I mean, what you would conclude from that, infer from that is that we would need to preserve the CUP process, correct?
I'd like a motion in a second to that effect.
So just so we're clear, so are we talking about bringing the suggestions forward as long as there's a CUP involved, or we're leaving everything the way it is because the CUP is required now?
It's your call. My suggestion to you as a
Correct.
board is that you authorize staff to begin developing a new section of the code expressly for reentry areas, and your desire is that it's by CUP.
I'm fine with that.
How do you feel?
I'm not, I mean,
I thought you wanted to preserve the CUP.
that's all, I don't wanna go down the road starting with, how we might, allow it in. I'm taking the director of corrections at his word. Pardon me, I may be naive.
Well, I get that. May I jump in?
Please.
I think what would help you is that this is one of those cases where it's better to have regulations on the book to say how you deal with something than to not, where it's loose and open-ended and we have to argue about it.
We don't have to argue, we have to vote on it.
No, right now today, I have to argue what it fits in. And if it doesn't fit within any of our categories, they can sue us and say, it's allowed right here.
Yeah, it's not, basically, it's not clear now, and this would, conceivably make it clear,
Thank you, Pat.
which makes my job a lot easier. And Dave.
I don't like it.
Okay.
You wanna comment further?
No, just that I think when I see, a provision for 50 residents are permitted, a halfway house may not be located, and district permitted, all these things, allow for, a bureaucrat to figure out a way to shoehorn that thing in and say, now I've got it by right. Because
Okay.
I've complied with all your little conditions.
But that's not true for a CUP, and what two
Well-
of your members are saying is they want this by CUP.
Why don't we do all our things that we do now do through CUPs with having extra legal language woven
We
in?
do. We have this kind of thing in our other CUPs.
For all of them.
We do.
Well, I haven't seen them.
Yes, you have actually.
Well, no.
When we bring them before you.
When we sit here,
Uh-huh.
we get a recommendation for or against, and we say, here's where it is okay for, and here's where it's against.
But for instance, in our mining regs, it lays out additional setbacks and other things like this
Mhm.
in a CUP for mining. Similarly, for CUPs for other uses we do. We have these kinds of further steps
Line
built into
endorsement.
the code.
And they're scaled to the use, so more intensive or potentially controversial uses tend to have more requirements, where, ones that are,
Right.
less problematic have fewer.
That's why you see a fair number of them on this one, is people worry about these things.
Well, think of the most onerous use you could devise for a property in Kootenai County. Okay? Should we then go ahead and make, all these, little conditions and things? No, we should just simply say no.
Oh, okay, I think I see where it's going. We could list out a use and say it's prohibited.
I mean, that could be one option that you forward to the planning commission. I mean, that's always a possibility.
Define it this way and then say this use is prohibited in all zoning districts.
I'd be in favor of that.
I don't personally feel comfortable with the legalities of that, because usually you only list uses that you intend to allow somewhere, in some place. But I suppose that's a board's discretion. What do you think, Pat?
It's, it's certainly a possibility and an option that the board could, that the planning commission could consider and then forward recommendations.
So in essence, we would be indicating that almost every use, or most conceivable uses, are acceptable, and we're gonna single one out as unacceptable. And I guess, and this is really more of a question for Pat, can you defend that in a court of law?
This one, I think it's an arguable point. I mean, I think I would have, I could make meritorious arguments that we do have the authority under Local Land Use Planning Act to do just that. And normally, you know, with a few exceptions, the state is required to go through local, you know, land use permitting processes. And this would be one of them.
I mean, it wouldn't be considered discriminatory?
Well, I don't think discriminating against the state is illegal, but,
You have to remember that.
you know, again, I can't guarantee 100% an outcome, but I do think, I would be able to at least make meritorious arguments that should be upheld if that were the case.
Do you want to comment further before we move on?
No, we can move on. I don't know why, I don't know what the house on fire is that we need to do this today. But, apparently somebody's got something in the plans for Kootenai County, and I'm not in favor of it.
Leslie?
I'm fine with sending both to the planning commission, saying, look, we have this template that, the director found, you know, we want a CUP attached to it, and explore options of prohibiting these altogether.
I'm good with
Both
that.
of those.
And then ultimately, we get to make the decision.
Anyway,
It is.
right,
And-
it's
and
your
on-
call on the code amendment.
Right.
Yeah, and public hearing,
Right.
you know, will be required, so
Right.
everybody will have a chance to weigh in, both sides.
Ought to be festive.
Yeah. And ultimately, I guess we also get to decide what goes before the public hearings. So when the planning commission does what
Yeah.
you
Right.
do,
Yeah.
and for the sake of a common understanding here, you come before us and you say, okay, here are the two versions. Here's a CUP that identifies the intended use and where it's permitted or prohibited. And here's another version which says we're identifying this as disallowed.
Mm-hmm.
And then we get to decide before we go to a public hearing what it is we're recommending. Fair
Right.
statement?
At the public hearing.
At the public hearing.
Right. The plan commission would recommend, you would decide.
I guess I'm still concerned that we're gonna get potentially tied up in court. Because this can be, go ahead, Ted.
I think it would be better and more legally defensible if we had a CUP, or, you know, approval process. And then, assuming the board said no, then we would have a record on which to base that decision that I could then defend. Just like any other use that's.
See, I get where Bill's coming from, because I think, and I'm not gonna try to put words in your mouth.
Good.
But I think but my understanding is you're trying to shut the door.
Absolutely.
Okay.
I took, like I said, I took the director of corrections at his word, period, end of subject. And the Department of Corrections is the only organization I know that would wanna put a community release center in Kootenai County. And there's nothing to preclude us, when we do have a conditional use permit, from having public hearings, is that correct?
Correct.
Right,
Okay,
yes.
so we could hear from the public,
Yeah.
Yes.
just.
If it were CUP, you would have a public.
That's right,
Actually.
and what I'm saying is, so that door is not shut by not doing anything at this point.
I do think we could put sideboards on any CUP to say things like you see there, that it has to meet this, and this, and this, and this.
Which is what this proposal.
Before it can actually go forward for a CUP. So that would limit the opportunity.
Correctional facilities are currently not one of the uses that requires a CUP.
Right.
So right now, we
Meaning-
have more risk of
Yes,
one coming in.
yes, arguably.
So you're saying that it's essentially currently by right?
Well, correctional facilities by right, there's a,
This isn't a
I-
correctional
this isn't the
facility.
first
I was just gonna say, which actually makes it worse right now, because it's not specifically.
The language, as I recall it, though, is broad about it being associated with correctional facility and so
Well,
on.
I think it's an arguable point, let's put
Right.
it that
I'd
way, and I
rather-
would rather it not be an
Right.
arguable point.
Agreed.
Mary, you wanted to, go ahead, please.
Yes, thank you, Mary Shaw, for the record. The public safety facility definition includes detention or correctional facilities.
Okay,
And
it's,
it
that
does
still doesn't,
require
that, yeah, that
a
still
conditional
doesn't,
use permit.
to me, that still doesn't
Yeah.
expressly include this use.
Right.
Doug, would you like, normally we reserve public comment to the very end, but because we're on this topic, I'm just gonna open it up briefly, so, in case you choose to speak, go right ahead, Doug.
Thanks. For the record, I guess Doug O'Conowitz.
And to give credit where credit's due, you essentially proposed this.
I appreciate
Thank
that.
you.
Yeah, thank you guys for being so responsive and working on it with a holiday in between, and it only took about 2 weeks. This is moving fast, and I really appreciate it. I think, from my sense of this conversation, I do think the CUP is probably the way to go. I think it avoids any preemption arguments. If you just categorically say you can't come, I think you open yourself up a bit more to a preemption argument. The CUP approach can be essentially as restrictive as you want, and as I understand it right now, based on the other things I'm hearing here and what I've already looked at, I believe, Commissioner Brooks, they can just come in and not ask you now. So if you get a conditional use permit on the books before they show up, you change the playing field. You don't have to worry about them being grandfathered in if they duck in before you've done something, and then they have to have you at the table, and you can decide whether they come at all or what things you want to consider. I think if you try and limit yourself to things up front and not use a conditional use permit, you might miss something that you care about later, but you didn't think about it. It didn't come up in your head in advance. So the CUP approach is a very good insurance policy. I also think it sends a very clear message that this is not something you're welcoming with open arms, but if it's going to come, they've got to satisfy you. And if they don't, you can ask them to go somewhere else.
Yes, sir. Thank you.
John Grimm.
John Grimm, yep.
Commissioner Brooks, I appreciate your willingness to take Director Tuwalt at his word. However, there have been enough conflicting statements among our group that's fighting this to warrant concern with that position. The second thing is, and I realize this is hearsay, but I have on good authority from inside the IDOC that, quote, we are building this in Kootenai County come hell or high water. The other thing is it absolutely is a correctional facility. Keep in mind these people are still incarcerated when they're being released there, because we questionably got to the legality of being able to release prisoners that have been convicted and sentenced to a certain time frame for one person, the director, to be able to say we're going to release these people early. Their response is they're not technically released, they are still incarcerated in our custody. They're just in your area, and there is a tremendous sense of urgency here.
So, what did I say? Sorry, Chairman. Commissioner Brooks, I do think that this is actually the best approach for you to have a better chance of stopping it. But if by doing nothing, I think you leave yourself exposed. I want to make sure that's clear.
I don't intend to do nothing.
Okay.
I don't think this is the time and the place, and I don't see the house on fire that we've got to call the fire department.
Mm-hmm.
And I think this is a tremendous rush to be able to put in a bunch of weasel words that will allow somebody to shoehorn the facility in Kootenai County by right.
That's why I like the CUP.
That's why I am for the CUP only.
Good.
I'm interested in the lawyer here in the front row.
Yeah, go right ahead, Dwayne. Dwayne Rasmussen, I'll announce it.
I was wanting to jump up and make responses all the way through this, but I couldn't.
Go right ahead.
I don't know if that I would want to do a legal analysis of it. It's not the old kind of system, although it's been around for a long time. But the people that are against this, we all stand in jeopardy of having real problems if this comes in here. We try to be kind to the governor because many of us like him, but this has to be stopped. Now, the means of stopping it, We could look at a variety of options, and I won't hold anybody against anybody for trying to do what the people want. But the people want this stopped and prevented, and it needs to go to Lewiston if at all possible. That is an option, and 130 beds is way too many. We can't have 130 beds. If they were saying 12, then they might have an argument. But the people don't want it. This is pre-parole. That's what needs to be beat into our heads if we can't figure it out. It's pre-parole. It's prison. It's not a halfway house like in the 1950s. This is inmates driving other inmates around in a bus. This is one of the worst things we could do for our community. And so whatever way we can stop this, legitimate way that we can stop this, needs to be done. Thanks. If you got a question on what I said, I'm happy to respond, but I don't care how we get there, it's just gotta stop.
I'm sorry.
Oh, my question to you would be, in the example that Director Callahan came up with, it says no more than 50 residents are permitted. I mean, could we say 25?
You can say any number you want.
Yeah.
Right.
No, go ahead, Leslie.
And once again, these are all the things you have to meet before you can even come forward with a conditional use permit.
Right.
And then the conditional use permit, we will have the process go through additional
Right.
conditions
Right.
if we approve at all.
Right.
And I'm inclined to go with both Doug and John's arguments. If you want to draw a line in the sand, and you had better be prepared to defend it, we can say, oh yeah, we can do that. Well, yes, okay, so maybe 98% of the public stands up and says we're opposed to it, but that doesn't mean that's what's going to hold up in a court of law. I would rather take a position that says, okay, here are the criteria, as Leslie was just referring to, and we can keep that criteria strict, and at least reserve the ability to still be assertive in our wishes as a community, but to be able to say, you know, we're not exactly drawing a line in the sand here, that we know should they decide to cross it, we may not necessarily have recourse. That's my concern. And I think that's what both John and Doug are expressing. And I think if we go down that road, it could be very dangerous for us.
And I think the CUP process will give the board, you know, basically veto power over this.
Right.
So, which I think, you know, goes to the, you know, the opponents that, you know, you can have your chance to make your case to the board where you arguably don't now, and then they make their decision. So, I would support going forward with the CUP process for this.
I'm sorry.
Summer Bush,
yeah, go
now,
ahead.
as you know, I'm for less regulation, but this CUP conditional use permit, can you kind of explain more in layman's terms the difference between more things by right versus conditional use? Because usually I fall under let's have less regulation, like with the code stuff, which I have been reading, but you know, what's the difference in those just in layman's terms? Because I'm hearing you guys speak with a lot of lingo, and I kind of getting it, but I know most people won't.
Director Callahan, go right ahead.
The easy takeaway is that a conditional use permit here and everywhere in the United States requires a process. The process is public. Usually in most communities it's 6 months or more to get in front of a hearing examiner or planning commission, and then the final decision maker is either a city council or board of county commissioners. That process is what makes it so that the public can weigh in, and notwithstanding any standards in the code, any legislative body can say this doesn't fit our comp plan in our community, and the conditional use is denied for those reasons.
Well, then what's by right then?
You meet certain minimums, you're in, you're done, you don't get a review.
Yeah.
Okay, thank you.
So,
It's a shortened process.
For instance, a single family home in Kootenai County in most zoning districts here, like agricultural, like suburban, is a by right use.
Yeah, in fact, we just made that a by right use in the commercial zone too, so a little less regulation.
Okay.
So,
So, and back to your point, somewhere in layman's terms, if you're in a 5-acre zone, you purchase a 5-acre lot, you're ready to build your home, you conform to the zoning regulation, you're off and running.
Pull a building permit for the home,
You
you're
pull a
done.
building permit
Right.
and.
But then there's no public hearing.
No, oh,
Okay,
no,
okay.
none whatsoever,
But then if I have the 5 acres and I want a different easement, then I have to go through, right?
Not
Like if I wanted
necessarily.
exceptions,
A different use.
Okay.
I'm gonna give you an example, a cargo container. So you can go build an under 200 square foot building right now
Right.
on your 5-acre parcel with that's by
Right.
right. But if you want a cargo container, then you have to go through the,
With the presumption
special
notice.
use process.
Yeah, that one's a
Okay.
special notice.
Yeah, special
Okay.
notice.
Right.
no, that
So
makes more sense.
essentially, this would say, okay, this, as long as you meet all these criteria, you can apply for a conditional use permit. And then you go through that process. We wouldn't just, at least I wouldn't be interested in just saying, okay, this is allowed by right. I would say, if you meet these qualifications, you can apply for a CUP, and we'll take you through that process.
And so if you did a CUP for the reentry thing, then they have to go through a longer
Precisely.
process with public hearings.
Precisely.
Yes.
Where by right, if they meet the minimum requirements, they go.
Precisely, and
Okay.
with a
Okay, that
CUP,
makes more
let's say
sense.
there were 10 conditions, hypothetically, that
Yeah.
are written into the CUP, and they meet 9, we can reject it for the 1.
Mhm.
We have that right.
Okay.
Say, sorry, you didn't meet all 10.
Well, and even beyond that, I didn't pull it
Go right
in
ahead.
here for simplicity's sake, but in the Land Use and Development Code, there are additional criteria that apply to every CUP. There are things like it has to be in conformance with the comp plan. It has to be so on and so forth.
Not in conflict with the public interest, I think is the other one.
And that's the catch-all where you can almost always find a rationale for denial if you get, I'm making this up, but 100 people show up at your hearing, 59 of them are opposed, that meets that criteria, you deny, you're done, and the courts will withhold you.
Right, and there's 7 of those criteria, is that 7?
That sounds about right, I don't remember right now.
Vlad, do you remember? Is it 7?
The CUP
Yes.
standards beyond this ones in Priest.
There are standard, for the record, Vlad Finkel with community development, there are standard procedures for evaluating any CUP, but as Director Callahan had stated, the conditional use section of our code has specific parameters and sideboards for any conditional use classification that may or may not work out for the applicant, such as minimum lot size, such as landscaping requirements, such as screening and buffering, parking requirements, you name it, noise. There's different impacts that, in the event the applicant cannot mitigate them with the conditions of approval,
Right.
the hearing body has the option to deny it, and that gives the applicant and the opponents the due process for voicing their opinions of the matter.
Okay,
Thank you.
I'm gonna cut it off at this point. Let's do how about moving to a motion?
Sure. I move that we forward recommendations to the planning commission for a code amendment with a CUP regarding halfway house / pre-parole Department of Corrections Reentry Center for
Their recommendation.
review and recommendation.
I will second.
Bill Brooks,
No,
Commissioner Duncan.
Aye.
Chairman Fillios.
Aye, and the motion carries. Thank you, everybody.
We'll also let the planning commission know about Commissioner Brooks's,
Absolutely.
about Bill's opposition. So your voice will be
Which is
heard as
duly
well.
noted.
Yeah.
Okay. So we're gonna move on to item C, which is the planning commission's recommendation